else. Thanks to Buffy and Kate for putting together a great group of people on a great topic. I'm really thrilled to be here. I read Beyond the Best Interests of the Child when I was taking family law in my second year of law school, 1973-74. The psychological parent was a brand new concept. So at the time you wrote about it, it was really quite a revolutionary thing to be writing about it. And by the way, without knowing this, I did assume from reading your article and the BG case that you had worked on that statute. It had your name like written all over it. So as you know from the paper I submitted, I am primarily today addressing one particular factual situation that challenges what it means to be a psychological parent today, and challenges the question of who a third party is and who a parent or natural parent is. And that is the example of a lesbian couple who intend to have a child together and do so through adoption or assisted reproduction, where only one of them is either the legal adoptive or the biological parent. And when they split up, what is the status of the person who is not the legal adoptive parent or the biological parent? And I just want to say parenthetically, and I say this all the time when I teach these materials, whatever factual situation you can come up with gay couples or lesbian couples, there are always going to be far more heterosexuals doing exactly the same thing. So the numbers of heterosexual couples in which the couple is unmarried and the child is only the biological child of one of them is enormous. And so when those cases come before the courts, they pose the same types of legal questions. And so, of course, I don't have to tell this group how important then a determination of parentage is under the relevant parentage law, parentage statutes. And one of the things that's shocking to me is how many states actually have no statutes at all that define what a parent is, and no statutes at all defining the consequence for parental rights of using assisted reproduction. So we talk about the Uniform Parentage Act, and I will be doing that today, but only a minority of states ever adopted the Uniform Parentage Act. And I think it is a big surprise that this is an area that has so little definition in state statutes. And then at the same time, the stakes are very high at being considered either a parent or not a parent. And if part of this is the constitutional dimension, which I talk about a little bit in the paper and won't talk about much here, but the other is that being a parent gets you everything, and being not a parent gets you nothing. And the everything, by the way, includes a shot at the best interest of the child. So, if you have nothing, you are really, really happy to be able to get into court and argue about the best interest of the child. So as we are criticizing it appropriately, nonetheless, it is, a lifesaver for somebody who otherwise is going to have no relationship with the child. So we have a number of examples now, and actually quite a large number of examples, of places where, in the situation I'm describing, the person who is, and I'll just use the term non-biological mother, understanding that includes the non-legally adoptive mother also, is going to be considered a parent. And it's happened in a variety of ways. So you have courts who have defined essentially a de facto parent and said, this person is a parent. You have had some statutes that do the same thing and say this person is a parent. You have a series of parentage statutes concerning assisted reproduction. And so the ones that are most directly applicable here, which we have in the District of Columbia and in New Mexico and in Washington, have taken what was the original idea in the 1973 UPA, a husband who consents to his wife's insemination with the intent to be a parent is a parent, something that was actually shockingly unsettled in 1973. In fact, for some earlier work, I looked at a lot of materials on artificial insemination going back to the 30s and 40s, and there was pretty much universal agreement that the husband actually wasn't the parent of the child, that he would have to adopt the child in order to really be the parent. And of course, that sounds completely ridiculous today, which shows something about the transformation in our ideas about parentage. And so in those 3 states, there are now gender-neutral and marital status-neutral statutes that achieve the same result. So instead of a husband who consents to his wife's insemination, it's a person, an individual who consents to a woman's insemination with the intent to be a parent is a parent. So that is a deliberate creation of parentage, legal parentage, in the context of assisted reproduction. Now, the interesting thing about these different definitions is that they're not all the same. And I just want to highlight the difference between intent and conduct. So the de facto parent statutes or court rulings that give legal parity to a de facto parent are all backward-looking, and they depend on conduct. They depend on the existence of a parent-child relationship, something we might call psychological parentage. It doesn't usually use that term, but it's quite a similar concept. The assisted reproduction statutes don't require any parenting at all. They are based on your intent, your decision as a couple to conceive a child using assisted reproduction, and then following through on that. And it turns out that these 2 different ways of defining parentage have enormous consequences. So in Massachusetts, for example, there is a perfectly dreadful case about a lesbian couple who chose to have a child together using assisted reproduction, and pretty much when the biological mother was in the hospital giving birth to the child, the non-biological mother decided it was a good time to leave the relationship and get involved with another woman. And when the biological mother filed for child support against her, the court said, we don't have parentage by conduct in this state, and so she is not a parent and has no, by contract rather, we don't have parentage by contract, so it doesn't matter that this is what she agreed to. She's not a parent, she doesn't have to pay child support. Well, in a state with a parentage statute like we have in DC or Mexico or Washington, of course she's a parent. You are a parent from the moment you consent to this endeavor that results in the insemination of a person, of a woman, with the intent that you're going to raise this child together. So the results are very different. In the conduct-oriented definitions, you can't be a parent until some time has passed, and some sort of unknown possible time. So, of course, the other thing I write about in my paper in terms of what makes somebody a parent is this fascinating development we now have in the law that's the evolution in this term natural parent. So, of course, when Bob was talking about natural parent, he didn't have to define it. It was obviously intended to mean the biological parent, and that's what everybody thought. And the most fascinating thing to me, thinking about this research and these cases over time, is that I write about this case in the paper in 1991, when the first lesbian couple split up, hit the California appellate courts in Nancy S. versus Michelle G. The argument was that we know this woman isn't the natural parent under the statute, but that's not the exclusive way to determine parentage. Pick these other ways. And the California appellate court said no. Other states like Washington State have said yes, but California court said no. But nobody argued that Michelle was the natural parent of those children. I'm pretty sure none of us thought for a moment that we could make that argument. And yet now we have 3 clear states and other possible states in which actually under the exact same statutory framework, the non-biological mother is the natural parent of the child. And this is a development that grew out of heterosexuals, in which men who were not the biological fathers were raising children. And it turns out that the Uniform Parentage Act said there's a presumption of parentage if you receive a child into your home and hold the child out as your child. And that also said that the rules for determining paternity could be used to determine maternity. And so once you had a man in California who was not the biological father, who wanted to claim parentage, you had the appellate courts having to say, okay, he received the child into his home and held out the child as his own. Now, we know he's not the biological father. Does that rebut the presumption of parentage because he's not the natural parent? And the California court said no, it doesn't. And then in the next couple of years, they dealt with the same thing with respect to women, not in the context of a lesbian couple, till they finally get to the Alyssa B. case, 15 years after the earlier case, in which the statutes were exactly the same as they were in 1991. And the court says she held the child out received the child into her home, held the child out as her own. The rules for paternity applied to determinations of maternity. She is a presumed parent. Are we going to rebut it based on lack of biology? Well, no, and by then there were several cases to cite. And this is not an appropriate action in which to rebut it. And the striking thing is that this is a theory that's viable in any state that has these criteria, including most recently Kansas, again, and as I talk about in paper, not a gay-friendly state. And I think Alabama will be a stretch for the Alabama court, but as I write about in the paper, it's all there. They've just ruled last year that a man is still a child's natural parent, even though he's not the biological parent, because of the holding out presumption. And they also have the rule that determinations of maternity can be made based on the rules for paternity. So we'll see about that. If a court ever accepts that, you heard it here first. Okay, going forward, the big challenge in determining parentage is going to be the marital presumption, and whether that gives the lesbian non-biological mother who's married to the woman who has the baby a presumption of parentage, and if it does, whether it's rebuttable and by what. 42% of gay people now live in a state where there is couple recognition, and about 38% of the population as a whole. So either marriage or the kind of civil union domestic partnership that gives you all the rights of marriage, which includes the parentage presumption. So that's a lot of people who actually believe that they are getting some kind of parentage presumption by being married to the woman who gives birth to a child. And to some extent, their fate is going to turn on how that state and those courts have dealt with non-biological fathers in numerous cases, in numerous contexts. The one thing I know for sure is that the question about what rebuts it is going to be way more complicated than I think most lesbian married couples think as they think about what it is they're doing together. So very briefly, let me just talk about the fact that these rules have not been universally accepted. And the most dramatic example now is New York State, which in the last few years rejected the approach that would allow for a judicial definition of parent to include a non-biological mother in this situation. And the reason that they did it, the most significant reason they picked, is the notion of indeterminacy. But I'm going to say something about it, and then I'm going to say why they got it wrong. So this is the quote from the New York Court of Appeals, asking for a criteria that would allow the non-biological mother to be considered a parent, a specific set of criteria that would amount to, I think, what we would all agree would be a de facto or psychological parent. The flexible type of rule championed by Deborah H. threatens to trap single biological and adoptive parents and their children in a limbo of doubt. These parents could not possibly know for sure when another adult's level of involvement in family life might reach the tipping point and jeopardize their right to bring up their children without the unwanted participation of a third party. So the problem with this is the kind of indeterminacy that court is worried about is very different from the kind of indeterminacy that Bob is writing about in his article. So the indeterminacy about the best interests of the child is about the inability to predict the future and the judge's lack of information that would allow a prediction of what the best interest of the child is like. The determination about whether somebody is a parent under any of these tests is pretty much backward-looking entirely. Whether it's about conduct or about intent, it actually is an act determination. It's not some prediction about the future. You look at how the family lived, or you look at what the intent was, and you get an answer to what happened, and you can assign parentage based on that. And so it's wrong to be concerned about the indeterminacy in that context, especially since by now we have actually a couple of decades of cases, or maybe 15 years of cases, in which it's actually not hard at all. I mean, there may occasionally be a problem at the margins, but proving intent and proving conduct has never been what's been difficult in these cases. These are families that start out as two-parent families and function as two-parent families. And that is perfectly obvious to anybody who looks at the conduct of it. It's just a question about whether the courts are going to credit that or whether they're going to stick with a definition of natural parent that goes back to a rigid distinction between biology and anything else. And so I'll stop there and look forward to Holning's comments, and then we can talk some more.
All right. I'm just going to grab my water.
Yeah.
All right. Well, first I want to thank Kate and Buffy for putting together today's terrific symposium. I want to thank Robert for serving as the inspiration for today's symposium. And I want to thank Nancy, whose work I admire and have learned so much from. Nancy, I love your piece because I think it so vividly illustrates just how much family formation has changed in the 3.5 decades since Robert wrote his piece. As you both have noted, the rise of assisted reproductive technologies, the increase in number of heterosexual couples having children outside of marriage, and the growth of same-sex parenting have really changed the way we think of families and parenting. And I think the context that you have shown light on, lesbian co-parenting, serves as a really illuminates just how much things have changed. Now, as for what you prescribe in your article, I agree almost entirely with what you've said, but in the interest and in the spirit of conversation, I want to pose 3 questions to probe a little deeper into the problem area that you've identified. And the first question you've already talked a little bit about is indeterminacy. So I want to push you on that a little bit. Secondly, I want to ask you why you've chosen to frame your article in terms of defining the term natural parent, as opposed to moving away from that term entirely. And then thirdly, I see your paper is really about functional families, right? So my third question is, if we're concerned about functional families, why do we stop at parents? And that brings us back to the conversation that Max and Emily were having in this morning, right? What about grandparents, right? Okay, so to my first question about indeterminacy, I think the paradigmatic case in your article is a relatively easy one because the lesbian couple there planned to have the baby together. They planned to co-parent at the outset even before the baby was born, and they followed through with their plan, and presumably we have evidence of that. But let's imagine a different lesbian couple. What happens if the mother with a son age 5 or 6 begins dating another woman? Eventually, the son really bonds with the mother's partner. At what point in time should we start to consider the mother's partner a psychological parent who ought to have rights with respect to the child? And the second question is just what type of rights should those be? Visitation, custody, full parentage rights. So I think you're right that it's a different type of indeterminacy than the type that Robert was concerned about, because we are backward looking, there's more of a factual record, but there is still indeterminacy with respect to line drawing. And maybe that's what the New York court was concerned about. And certainly we could create legal doctrines that limit and cabin that indeterminacy. We could say maybe, when the biological mother's partner moves in, we could draw the line there, maybe when the son starts calling that other woman mom. But I'm not sure that any of these lines are particularly satisfying. And so I would be interested in hearing your thoughts about that. But beyond creating some sort of doctrinal tool, we might think about moving towards formalism of a sort, right? So should we view de facto parentage rights for same-sex couples as a sort of temporary solution with the ultimate goal of making second parent adoption legal and moreover more easily accessible across the country? In such a regime, the lesbian couple, if they want the psychological parent to have rights, they need to go register the psychological parent's relationship formally through some sort of second parent adoption or registration program. This would solve the indeterminacy problem. Now, I imagine that Nancy would say, and I think I would agree, that second parent adoption, at least as it is currently conceived, is too costly and is too onerous and therefore is too much of a burden to place on these families. But at least as a thought experiment, I wonder if it's worth considering ways to make it easier for psychological parents to formalize their parent-child relationships so that we minimize the number of difficult, indeterminate cases. For example, we talked a little bit earlier about Australia and how easy it is to get a divorce there, right? And maybe that can serve as some inspiration. For example, what if instead of having second parent adoptions that require lawyers and judicial resources, we create some sort of low-cost social parent registry administered by a clerk's office? And this is just a thought experiment. It could be something like a cross between a putative father registry and a domestic partnership registry, tailored to the goal of formalizing a child's relationship to his or her social parent, documenting the consent between the social parent and biological parent to raise the child jointly. I imagine that even if we set this up, a good number of social parents who ought to register their relationships will still fail to do so. But how much of those exceptional cases should we be willing to tolerate? We might want to create a regime that encourages registration and makes registration the norm, but still allows courts to take a functionalist approach to recognizing social parents under some very compelling circumstances. So I'd be curious to hear your thoughts about that, how to deal with indeterminacy, whether it's through doctrinal manipulation or through moving towards a more formalistic system, right? My second question is about the framing of your article. You decided to frame your article around the term natural parent. You started by recognizing that Robert didn't define this term in his article, and then you proceed to argue that natural parent should be defined capaciously so that the term is not limited by biology, and instead could extend to lesbian co-parents. My question is, why frame your article as an expansion of the term natural parent as opposed to challenging this discourse that centers on nature? In other words, why not come out and say that the term natural parent in Robert's article should be replaced with simply the term parent? Alternatively, and perhaps more radically, we might think about privileging social parents as the category that we give primacy to, and think about treating biological parents and adoptive parents as presumptive social parents, but the discourse would center around who has the social relationship with the child. Again, in that framework, social parenthood, psychological parenthood, is what our discourse would give primacy to. And what sort of norms would we further by taking that framework instead, adopting that framework? So in sum, my second question is about your decision to frame your article around this idea of natural parenthood. shouldn't we adopt instead a discourse that reminds people that nature doesn't necessarily create families, and it's human conduct and decisions that creates families? And, I was thinking as I was coming up with this question, your work on marriage, this idea that, because in this piece you seem to be working within the existing framework, right? Natural parent is a term in Robert's piece. This is the term, it's the dominant term that's in some statutory frameworks. And in your work on marriage, you have kind of moved beyond the kind of dominant mode of thinking, analytical mode, discursive mode, to think beyond marriage. Should we be moving beyond natural parents as the organizing unit of analysis, right? And my third question similarly draws inspiration from your work on marriage, right? I think you've written insightfully on how marital relationships are not the only caregiving relationships between adults that is important and therefore should have recognition. So by extension, might we say that parent-child relationships are not the only caregiving relationships between adults and children that are important and warrant recognition? So let me give you an example, and I think this builds on the conversation that Max and Emily were having earlier today. Imagine that a single mother who was contemplating abortion decided jointly with her parents to give birth and raise the child with her parents' financial, emotional, and logistical support. In this example, the grandparents are part of the prenatal planning process. The grandparents also contribute to the child rearing as much as their daughter does. So these grandparents are distinguishable from the grandparents in Troxel, so we could bracket that case for now. These grandparents are just as involved and just as psychologically attached to the child as the lesbian psychological parents in your paper, except that they don't hold out their grandchild as their child. So they wouldn't trigger the holding out provision in the UPA, right? Instead, they hold out their grandchild as their darling grandchild. Is that distinction that we're making simply that the grandparents didn't hold out the grandchild as their own child enough for us to draw a meaningful distinction between the grandparents in my hypothetical and the lesbian co-parents that serve as the paradigmatic example in your article? And I know maybe this question is a little unfair because you note at the end of your paper that that's a topic for another day, but I'm not sure that we can really bracket these additional adult-child relationships when your article is so strongly premised on the notion of functional families.
Thank you so much. Okay, so really quickly. So I'm going to take care of the natural parent question first. That one's easy. And that's that I am actually working within the specific framework of statutes that use that term, which is what the 73 UPA does. The 2002 UPA did away with it. So in the current UPA, they just use parent. But to the extent that states still have the term natural parent, there is always going to be the question about what natural means in that context. And so having discovered the ability to argue that a presumption is not rebutted because someone is not the biological parent, it seems to me is going to be a continuing issue since natural parent appears not just in the UPA, but in so many other cases over time. Even in the Miller-Jenkins case in Vermont, the very first articulation that Janet Jenkins was also the parent of the child her civil union partner gave birth to, there was a whole little thing about why the fact that she wasn't the biological parent didn't mean she couldn't be the natural parent. So I feel like I'm happy to abandon it when the statutes abandon it, but for now I need to use it. On the first point, so I think what we're closer to than the social registration you're describing, which would be problematic for the adoption field generally, so I'll sort of leave that aside, is marriage. I mean, this is the problem that the New York court, while completely decimating the relationship, the notion of a parent-child relationship based on psychological parentage and functional parentage, said, but they were in a civil union. that makes her the mother of the child. So they use both second parent adoption and being married or in a civil union as the bright line basis for determining parentage. So that's what works in New York now. And you can get married while the woman is pregnant. As long as you're married when the baby's born, you have essentially done what New York says you need to do to be considered a parent of the child. And I think that is enormously problematic, because it means that children in New York born to a married lesbian couple have two mothers, and born to the same two people, if they're not married, they have one mother. And to me, I mean, this is a conference I did a couple of years ago at my school called The New Illegitimacy. I mean, that this is, we now have illegitimate children in the gay and lesbian community. They're the ones whose parents aren't married. Like, that sounds really familiar, except I thought we did away with it 40 years ago. But we actually do now have a distinction based on marriage, and that to me is the biggest danger of the sort of formalism. And I think we can't stick with formalism anymore, because it doesn't match how people live their lives, and that we are just required to think about the families people are really creating rather than the ones that fit some particular model. And I do think the question you started with about the 5-year-old whose mother gets a new partner is a different situation. I mean, that's a step parent. And so that's a conversation about step parents. If it were up to me, I would allow a step-parent adoption that didn't terminate the parental rights of the non-custodial parent, especially if the three of them were all in accord. It's one of the more shocking things about our law, I think, that even when all three people are in total agreement that that's what they'd want to do, that they can't do it. And I don't know whether what's going on with the few third-parent adoptions there are for same-sex couples and another person will start a conversation to undo it. I think the fear that judges have about three-parent adoptions among gay and lesbian people, usually, but not always, the semen donor and the lesbian couple. I think the fear is about step-parents. The fear about three parents is, what are we going to do with these vast numbers of children who actually have three functional parents? And so I think that question is a different question and a really important one. And for the bigger functional family question, I think this goes back to a comment I made about Bob's article, which had to do, of course, with the Times. It didn't talk about visitation rights at all. There was no question about whether somebody outside the sort of more nuclear unit should have some access to the child under some circumstances. And I think that's a tougher call. I might not go 100% as far as Emily does to make it sort of all or nothing. And I'm still struggling with that one. And, you know, I'm also struggling with more than two parents, which I think the law is very much struggling with. So let me just open it up. Yeah.
I was just going to push back on a few things real quickly. Sort of the natural
Yeah.
parent, I mean, as an adoptive parent, until the language changes, there's going to be this, it's going to, you know, keeps the hold on biology. People hear natural, that has a meaning. It is, you know, we sort of play around with things in law, but that one I think is so powerful that, you know, I would say, even as you talk about it as an advocate who can affect change, capturing the problem, even if when you work with a particular statute, you have to use their language, because it's, that runs so deep, and it has such a cultural message, I think. A couple of things real quick. I was thinking about this idea of how much we have our law match our families, and how much we, you know, we try to make the law solve some other problems. And I think some people will know this much better than I, but the history with common law marriage, and so the idea that it used to be a lot harder to, you know, get a marriage celebrated and get it registered, and we wanted to recognize how people were living, and so we allowed for this recognition in the sense through the common law process. And the easier it got to go through a process and register and keep a record, the more that has dried up, and most states have now moved away from it because there are complications that come with the fact that we aren't going to know until we have the adjudication and all the things we've been talking about all day. So it seems like there are trade-offs there, and to the extent that one can do this in a way that's pretty straightforward. It does require people to change what they do, but we don't say, oh well, we can't get, you know, we better not have people whatever, fill in the blank, get a driver's license, or register, kind of can come up with the silly examples. But the idea is, so we do ask people to do some things, even if it disproportionately burdens people without resources, and even if some people are going to fall through the cracks, we're going to have to deal with it. If we think in the, over time, overall, it helps us all function. And it seems like this might be a world where we do just that in a way that's really valuable. The last thought, very quickly on that subject, when you said a registration, is I think that sort of what we're seeing with same-sex marriage is, there is one thing that's good about getting the rubber stamp from the court instead of from some other registration process, which is full faith and credit. Seems to be much more protective in that context. To the extent we want to remove, this is a very pragmatic point. I don't really agree with a lot of this full faith and credit analysis, but one thing with the United States, just to sort of go back on the kind of whether you go to your courts or not for divorce and marriage and the like, is you do for divorce, and therefore they're now under full faith and credit is much greater sense of obligation to recognize across state lines. And DOMA aside, it's not clear how to think about that in same-sex marriage because it's not done through the courts. But that's sort of a technical point.
Or parentage statutes.
And that's what made me think of it was a comment about all of the sort of the
Yeah, there's no
mechanisms
question
of
about it. I
identifying
mean,
parents.
everybody who does this work will say either an adoption or a parentage judgment are the guarantees you need to cross state lines and have your parentage recognized. I mean, as a practical matter, we're going to be sorting out these parentage issues for gay and lesbian-headed families for a couple of decades at least. I mean, just because the cross-state lines are going to be so significant. And so, yes, second parent adoption or a parentage judgment are critical to that level of security. The problem is people aren't doing them, and they're not doing them for a number of reasons, the most obvious ones being they cost money, you have to find a lawyer, and they're weird. You put yourself into the court system when your family's perfectly fine, and so people don't do it. And to have that be the line then between whether a child has two parents or one just seems to me to be fundamentally misconstruing what that child's family is, and that the instinct behind the notions of attachment and stability that created psychological parenthood as a concept is those instincts are still true. And to have children lose a parent because of this sort of formalism, I just think is unacceptable. And I know there are some costs to the process, but I'm clear about how I weigh them. Someone else may weigh them separately. I'm also an adoptive parent, and so I am only using natural parent when it's in the statute. Or when it's in the court, the sort of common law method of determining who somebody is a parent. I'm not using it. I'm not trying to resurrect it, from the places it has met its demise. All I'm trying to do is say, if that's what it says in your law, it doesn't mean it has to be a biological parent, that in fact the term natural parent has been expanded in other contexts. So, thanks. Yeah, Claire.
Yeah, Nancy, I want to push you a bit more on the formalism versus functionalism, right? So what I heard you say was that you're concerned about formalism because it doesn't match how people live their lives, and that you think functionalism is okay because we sort of know a family when we see it, right? You say there's sort of no question that these lesbian families are families. But I'm not so sure that's right in terms of the trade-off, right? So what I'm concerned about with the functionalism is the level of scrutiny to which it subjects families, and in particular, the standard that is used to determine who's a family and who's not a family. So back to the ALI, right? The whole idea that in order to be a functional parent, you have to live in the household, right? We think about how increasingly couples don't live together because one of them has a job somewhere else. That's the only way they can survive economically, or all the different ways in which people construct their families. And if, in fact, your standard is you got to look a lot like the sort of, more traditional family, that's a lot more demanding and more sort of liberty constraining than walking down and registering your relationship, and then you can live however you want. So I guess I just wanted to hear you talk more about that.
Yeah, so I guess the other thing I would say, we're not going to have, we're not anywhere near where we would have parent-child registration.
Mm-hmm.
I mean, you would essentially be doing away with step-parent adoptions. You would be saying nobody ever is going to scrutinize this. And, and anytime you're adding a parent to the child's life, you just sign this registry and it's done. So partly, I think, that's not going to happen. I think marriage is a dreadful bright line for the same reasons it was in 1968 when we started undoing it as the bright line for heterosexuals. And I think that I think I'm not trying to eliminate those things where they exist. I'm just saying they're not sufficient. And so there is a case, an appellate case in California, where the court said these people didn't live together, but the non-biological mother still received the child into her home and held the child out as her child in a very complicated fact pattern that was in part determined by the fact that the non-biological mother was in the military. And so she had don't ask, don't tell to be afraid of. And so it's a very lengthy decision. On the other hand, there's an older decision from New Jersey that I was troubled with at the time that appeared to turn on, one way of looking at it was that the non-biological mother, that the couple was sort of in the closet. And so it was easy to think that the non-biological mother wasn't really functioning as a parent. But we have had, if you go back to the Wisconsin test from 1995, we've had close to 20 years now of some functional tests being used without a whole lot of problems. And Carlos Ball wrote an article a couple years ago about basically trashing the New York Court of Appeals for what it said about the indeterminacy, and actually pointing out that New York's own case law involving men and fathers was way more indeterminate than what Wisconsin had done in its standard, more than 15 years ago. And so will there be mistakes? Sure. There's no way to avoid some mistakes, but I feel like the parent, since we are talking about the child's perception of a parent, I think we can capture that. I think courts can capture that by looking at things that are sometimes in specific tests or looking more generally. But I love our consent to insemination statute. You sign the form. In Washington, D.C., when you give birth in a hospital, because we changed our birth certificate statutes also. If you don't change that, the vital records people don't know what to do. We changed our birth certificate statutes. A lesbian couple shows up in a hospital in D.C., the social worker who comes to give the paperwork for the birth certificate, there's a form, a vital records form, and it's called consent to insemination. And we sort of made it up, tracking a little bit the voluntary declaration of paternity thing, because it includes a statement on it that says, by signing this, you are taking on these obligations and saying to the birth mother, by signing this, you are making it clear that this person also has these various rights. You sign the form, you're done. You get a birth certificate with 2 names, and under DC law, you are both parents. Will it travel interstate? That's a problem. That's a problem in all of this if you don't have a judgment. But so the judgment is the best thing you can get, but that's the brightest rule you can write. You consented to the insemination, you both intend to be parents, you sign the form, it's done. And I'm all for that. I just think it's not going to get everybody. And so we also have de facto parents in DC. And anyway.
I think we're going to need to get you. I've allowed us to fall 12 minutes behind. I don't know how I did it, but I don't want to short the people on the other end of
Yeah.
this. So, thank you.
Thank you.